without any notice, but without any notice was quite illegal, justified, and unarbitrary, and no such notice was they said without any notice and without justice. It is right. Finding is minor. In this case, on consideration of the statement of the NW, the NW, substantial NW2, 5 NWs has been examined. The lady workman in herself and WW1 no staff for the union and the preliminary point about the planning of the domestic inquiry by the tribunal held the inquiry as quite fair and proper. Mr. Sutton and Prasad Lanek Union representatives of the workmen submit that the continuously served for 29.5 years since his appointment firstly at till he began on 17/71 and thereafter was illegally removed from service on the allegation of impersonation of Dodi in Israeli and without proper inquiry by the management, so he is responsible for the full bad wages and consequences upon the court of law. My submission is that the case that is admitted that the case has been removed from service under clause 28. Kindly see the removal order, that is the annexure 1, page 31. That is the removal order. In first submission, my first submission is case cannot be decided under clause 28. Rather, it is the case of 27.2. Kindly consider the annexure. Certified copy of the standing order annexure 2, page 38.
Where is the order of removal?
Page 37.
That is the order of it.
Page
37 is annexure 1. That is the order of removal.
That copy also.
That was exhibit W1 before the court paper.
Page 37. That is also there. Removal from service from the company. Whereas in the inquiry conducted with your knowledge and participation from the police investigation report received from the SP Dhanbad, it has been established that you have been entered into the employment at Patati Puliati in the name of Srimati Rohini Deshwari, wife of Kali.
That's right, we have seen that. Clause 28 has been mentioned.
Yes, madam. Clause 28 has been mentioned. Am I correct, Mr. Manda? You are hereby removed to rendering duties in the company under clause 28 of the certified standing order of the company with immediate effect beginning impersonation after entering into the employment by published manner in the name of actual employee Satanka. Malakai is on the certified standing order, that is annexure 2 in the next page 38. My submission had 28 is not applicable in my case, and without any inquiry or charge sheet and so far, no person can be held guilty for the fraud. That amounts to fraud. You will kindly see the page 39. 39 is certified standing order. Kindly consider page 40. 20 is mentioned.
Yes, please.
Page 40, special procedure in certain cases where a workman has been convicted of a criminal offence in a court of law or the chairman or where the chairman and managing director of the company is satisfied or this is recorded in writing that it is not being extended or against the interest of the security to continue the employment of the workman, the workman may be removed of discharge from service without following the procedure laid down in the standing order principle. My submission 27 is marked because no criminal case was pending against me and the inquiry so far inquiry that is beyond the back and whatever may be history and that is internal, that cannot the basis of the termination. And kindly turn my lord before that page 39, 27.2.
Do you want to say that no domestic inquiry was conducted?
Yes, no inquiry proceeding was initiated, no charge sheet, The inquiry was conducted by
Then
the.
how the inquiry was held to be fair and proper? How the inquiry was held to be fair and proper?
Whether can be considered if the charge sheet has not been issued, if the departmental proceeding is not issued, how the impersonation and the fraud can be proved? That is a series of statements on that point. Departmental inquiry proceeding and the inquiry by the SP or whatever this person cannot be taken as inquiry according to the law. Even there is a decision, the business inquiry, it cannot be the basis of the punishment. That may be the basis of the charge sheet. And 27 to what is my language? 27 is procedure for dealing with the case of misconduct. Definitely the charge for impersonation is the misconduct. And it's the charge sheet. I have repeatedly said no charge sheet has been given, and that is correct, no charge sheet has been given, no inquiry proceeding has been given. How we are saying this? And whatever evidence. And 27.2 is one. First of all, we under what clause may have service has been dispensed with removal. That is 28. 20 is not applicable in my case because no criminal case.
Yes, madam, what do you have to say?
We have three things. First, if we go by the clause 28.0, there are two condition precedent for the application of clause 28.0. One is the conviction and the other upon the satisfaction of the director person. That may I read it once again? That is at page 40.
Yes, read it, please.
There a workman has been convicted for a criminal offence in the court of law, or where the chairman cum managing director of the company is satisfied for the reason to be recorded in writing that it is inexpedient or against the interest of the security to continue and to employ the workman may be removed or discharged from the service without following the procedure written in the standing order number 27. Now coming to this minute, the impugned above.
The satisfaction has been exhibited.
Milord, there was an inquiry was held. Annexure 7 may kindly be seen. And there was a report called from the police. Superintendent of police has given a report that she is a imposter. That has also been annexed in the writ petition itself.
That's right. We want to
Annexure
know.
7 may kindly be
You
seen.
want to invoke the satisfaction of managing director or the chairman.
Yes, that
Right?
is.
There has to be some material, no, to show that they applied their mind, they were satisfied, and thereafter they were removed. Under whose orders?
Annexure 7 may kindly be seen.
Annexure 7 is the inquiry report.
Yes, it is an inquiry report.
Then
As
where she
directed
did not
by-
participate.
As directed by
Where she
DPY.
did not participate.
Huh?
This is not an inquiry report arising out of any departmental procedure.
No, she participated. She was inquired.
No,
She
you see,
along with the
you
workman,
can't have
she-
two things. Clause 28 says dispensing with inquiry a person can be.
Yes.
Right? You invoke clause 28.
Yes.
Therefore, the fact remains that since you have invoked clause 28, there was no domestic inquiry.
But here, even after invoking clause 28 leadership, a preliminary inquiry or the inquiry was conducted, even the inquiry was done from the police side. And thereafter,
See, inquiry happens only when a charge sheet is issued. Without issuance of a charge sheet, you cannot have a roving inquiry. And you say that the person has participated. Unless the person knows that for what purposes a person is inquired, the inquiry is conducted, and the person is given an opportunity to participate, cross-examine witnesses, produced his or her own witnesses, and then an inquiry report is prepared. You cannot have a roving inquiry without a charge sheet. Was any charge sheet issued? No.
a charge sheet was not issued. That is an
So this is not an inquiry in terms of domestic inquiry at all. And therefore, I have seen the order from the court, order dated 28/2/2012, wherein the domestic inquiry was held to be fair and proper. It refers to only section 28 and says that I find that after holding inquiry against a workman who also participated and her services were terminated, and thereafter she was removed from service under clause 28 of the certified statute. In absence of issuance of a charge sheet, how can you terminate a person?
Yeah, Firestone judgment, if we go by that para.
This is not a domestic inquiry where no charge sheet is issued.
No, in Firestone judgment it has been held that even if there is no inquiry at all, or there is there is some error in the domestic inquiry that has taken.
This
Both.
is no inquiry, that is also justified.
Yes, yes. It
Removal
is
without inquiry.
inquiry without, even that has been mentioned in para 33 of Firestone judgment application, wherein it has been held that before the court, before the labor court, the party can adduce the evidence.
Yes, if there is no inquiry.
If there is no inquiry, the parties may adduce. Now, when this case was instituted, the reference was made before the labor court litigation. Both the parties were there. Both the parties adduced their evidences.
No, no evidences were adduced because of the reason that straight away after holding that the inquiry is fair and proper, the matter was posted for hearing on merits.
Both the parties exhibited their documents.
No, exhibited their documents in connection with the domestic inquiry, isn't it? But once this inquiry was held to be fair and proper, then
And that order has never been challenged. In February 2012, the inquiry was held to be fair and proper. In August 2012, this award was passed. But that order has never been challenged by the petitioner before any court of law. Meaning thereby that only section 11A would come into play, leadership, wherein the quantum of the punishment has to be seen by the court below. And
have you challenged the order dated
Never.
28 to 2012, madam, by which the inquiry was held to be fair and proper?
I think it is not directly challenged, but my submission is that when the reference has been made, so far removal is concerned, then all constitutional action.
No, no. You see, the law is that the legality and validity of the inquiry has to be decided as a preliminary issue, but the cause of action to challenge the same arises only when the final award is passed. This is the procedure I guess.
But when the when the removal order has been that is reference has been made when the removal order. That is our main point is that 28 is wrong because that is not the case for criminal. And my submission is that without any charge sheet and without departmental inquiry, no man can be punished for the fraud. Impersonation is a fraud. That is a serious case. When I have stated in paragraph 5 and 6, no charge sheet has been submitted, no inquiry was proceeded against me in terms of the inquiry of this report, and the clause 27(2) has not been complied with. Therefore, my case is concerned. And there is a series of decisions my last court cannot be proved without any charge sheet. In this case, there is another point. The complainant is the son of the so-called real Rohini, and he has not been examined in this case. Therefore, complainant has not been examined, and more so, no inquiry proceeding, no charge sheet. I did the reply in paragraph 5 and 6 in that.
You see, once the inquiry is held to be fair and proper, there is no question of further evidence. The material which was there at the domestic inquiry is required to be seen and decided.
The domestic inquiry, that is the decision, my lord. Preliminary inquiry cannot be the basis, can be the basis of the inquiry proceeding, but that cannot be the basis of the punishment. And the complainant, if the complainant has not examined in that proceeding, there is decision on the concerning. The inquiry which has been done by the examination cannot be done as an inquiry according to law. There is no charge sheet.
We want to
no
know
inquiry
from you.
proceeding.
We want to know from you that there was a specific order. The consequence of an inquiry being held to be improper, and the consequence of an order of the preliminary inquiry held to be improper are totally different. If the inquiry is held to be improper, then the entire the entire evidences are opened to the parties and they can adduce their evidence. But once the inquiry is held to be fair and proper, there is no question of further evidence of that nature, and then the matter is to be decided on the basis of materials which have been placed on record in the domestic inquiry, and primarily the court sees the proportionality of the punishment given in a particular case.
Mala gave the great time to consider the judgment. That
Which
is not the Supreme Court judgment. Inquiry procedure and departmental inquiry has been discussed in 2013 volume 4 Supreme Court cases 301. And it is that is the paramount case in
2013, just a moment, 2013,
volume 4 Supreme Court cases 301.
301, party name?
Nirmala J. Jhala.
Para number?
Para 41, 61, 14.
41 to
41, 62 and 14.
52 and 14.
1, 4. Inquiry procedure, natural justice, preliminary inquiry, reliance on extent to which permitted. Yet evidence recorded in the preliminary inquiry cannot be used in a regular inquiry as the inquiry is not associated with it and the opportunity of cross-examination person examining the preliminary. I have not given any opportunity to cross-examine. Thus, using such evidence violates principle of the natural justice and natural justice, since cross-examination is an integral part of the natural justice. Preliminary inquiry may be useful only to take prima facie clue, that is correct, as to whether there is some substance to allegation made against the employee which are warranted for the inquiry. Besides preliminary inquiry and this report losses significant importance once regular inquiry is initiated by issuing a charge to the delinquent. I will not because I am reading taxidom B. Preliminary inquiry and its report losses significant importance once regular inquiry is initiated by issuing a charge to the delinquent.
This particular case, just a moment, this particular case which you have cited, was it arising out of an award passed by the learned labour court? That makes a lot of difference. Kindly let us know.
Law is same.
No, law is not the same, madam. Law is not the same. The labour court is first required to consider whether the inquiry was held to be fair and proper. This is a full-fledged adjudication. Natural justice is to be seen and all other procedure is required to be seen. And then if the inquiry is held to be fair and proper, then the court hears the matter on the basis of materials produced at the stage of inquiry and then decides whether the punishment has been rightly come across, and then whether the punishment is disproportionate or not. Isn't it? So this judgment is not applicable, madam. Please don't cite a judgment which is arising out of a service record.
If I say that is not an inquiry according to law, whether I can submit that or not, we have review of that judgment and another judgment. Inquiry proceeding which I have learned to me that is charge sheet that is initiated, the departmental proceeding started from the issuance of the charge sheet and completed by issuance of the final order, punishment order. That is the inquiry proceeding. And is the inquiry proceeding? Is the inquiry proceeding satisfied the
That is why I am repeatedly asking you that you have not challenged that order by which the inquiry was held to be fair.
My lord, kindly consider if I challenge that there is a law for merger. If I challenge the original order, it is not required because I raised that point in this case that no inquiry was initiated, no findings my fault in accordance with the law, therefore no punishment can be given to me. This is not a case under clause 28. 28 is only for the and who passed the removal order? That is the project officer. That is the management. Project officer is the management to pass the removal order under clause 28. May I put the question to myself? and the complainant has not examined. And there is also a case law that is 2013. When it is ordered by the Ayukt to 2011 column 6 376. If the complainant is not examined, the charge cannot be taken.
There is no charge sheet. They admit that there is no charge sheet. They admit that there is no charge sheet.
Yes, if no charge sheet, no regular inquiry, I think that was the admitted. If no inquiry proceeding, how the scientists from the Avatar Singh case, Kamal Narayan case,
They've got biased on that.
Paramount case.
They've got biased on that. Para 33.
There are
33.
8
Firestone judgment.
Or may I read it? It's convenient.
I just want to know from you, whatever she has to say, we will hear her certainly. It is already 4:30. I want to know from you that once, as per the records, the order has been passed under clause 28. It is admitted fact that there was no charge sheet. You have exercised your power under clause 28. So, her contention is that, so therefore we want to see, you say that the clause 28 can be invoked irrespective of a criminal case, and the satisfaction of the management is to be there. Management is, the specific authority is also mentioned under clause 28. Which is that document which shows the satisfaction of the management? Because if the inquiry is held to be fair and proper, then also the scope of consideration of the materials before the inquiry officer is still open for the court to consider. Right? So please tell us which is that document on the basis of which you can say that the managing director of the company has applied his mind in terms of clause 28 and has passed on. Admittedly, there is no FIR. There is no FIR.
There is no FIR. There is a delegation of power, your lordships, under the certified standing order. And lordship, thereafter, the director of personnel, your lordships, he has considered that your lordship will find annexure 7, page 55.
This is annexure 7 is just an inquiry report. This is not a
The starting line, as directed by DP, why it is noting that it is to conduct.
Thereafter, where is the application of mind? And where do you say that clause 28 could also be exercised through the delegation of power? Because clause 28 is a very serious clause.
This it is a case where, your lordships, a person was found who is not our employee, a non-employee was found to be working in place of an employee.
See, it's a very serious charge.
It is a serious charge and
Yes.
it was established, your
It's a
lordships.
very, how do you say established? Because there was no inquiry.
No,
Please, there is no charge sheet.
I'm just
Without a charge sheet, there cannot be any inquiry.
Yes, I'm coming to you, lordships. Charge sheet, lordships, or a departmental inquiry. An employee has a right who has a protection under Article 311 of the Constitution of India. A person who is not our employee.
Who will
What?
decide?
It was found, your lordship, even she could not identify the husband of the original employee. The son, her own, the person who
You
is.
see, all these things could have taken place had she been subject to a disciplinary proceedings by issuance of a
That
charge
is the
sheet.
exact question which will fall for your lordship consideration.
Yes.
In one case, I'll just show, there is one judgment of the division bench of this court, your lordship. Lordship, may kindly see this judgment. Exactly similar was the case. There also an impersonator was found to be working. Para 6 onwards. This is LPA number 420 of 2017.
LPA 420 of 2017 decided on 11th of May 2018. Yes, where is it?
Para 6 onwards. Looking to the earlier order passed in LPA number such and such, it appears the Central Conference Limited was directed to hold an inquiry and ready to reference para 6 and 7 of the order passed in LPA number 33 of 2010 reads as under. Be that as it may, the order of superannuation of the petition was rightly not sustained.
This
has
is not
rightly been-
arising out of this
No,
labor
no, I'm
code
just,
award.
Lordship, I kindly see para 7 onwards. I'm just reading out here, Lordship. Thus it appears from the aforesaid order passed by the division, Central Coffers Limited was permitted to conduct an inquiry. The permission was given mainly for the reason that it was argued by Central Coffers Limited that over and above the dispute of age, there is also an allegation of impersonation and the appellant was an impostor. In view of the aforesaid permission granted by the division bench dated such and such, a member of the committee was constituted to hold an inquiry. There was no
For
departmental
the
inquiry.
charge of impersonation.
Yes, no departmental inquiry. I am coming to it further. There was no charge sheet. A committee was constituted for holding an inquiry by Central Coffers Limited for the charge of impersonation and for the charge of this appellant was an impostor. Adequate opportunity of being heard was given to the appellant. Here also, Lordships. It was given to the appellant and a detailed inquiry was conducted by the inquiry committee of 3 members. On basis of documents on record and on the basis of the evidence, the inquiry committee has given its report dated 13/3/2013. As per the report, which is at annexure 5 to the memo of latest patent appeal, it has been observed that inquiry committee in their report that allegation of impersonation and allegation that this appellant was an impostor has been held to be proved. Thus, it appears Central Coffers Limited has raised 2 objections. One, about date of birth of the appellant, that it is not settled that herein above that writ petition, latest patent appeal on dismissal of special writ petition. About impersonation, about the fact that the appellant is an impostor and he is not the son of Jugal Mochi, who has taken voluntary retirement from the service of Central Coffers Limited. Much was argued by the counsel for the appellant that his writ petition was allowed, then latest patent appeal preferred by Central Coffers Limited was dismissed and SLP preferred by Central Coffers Limited is dismissed on first allegation and therefore second allegation cannot be inquired into. This contention is not accepted by this court mainly for the reason one. Both the allegations as stated herein above are separate and independent
This
of
is
each other.
this is not a case law on a point that inquiry can be held, domestic inquiry can be held without a charge sheet.
Lordship, can we come to the judgment of Vishwanathan Pillai, whether a person. Here it was a case, Lordship, that was a much better case than this, where the allegation was. Lordship, you can. Para 7 year, Lordship, you can see.
This is again Kumari Madhavi. False caste certificate.
False caste certificate here also says that the person who
See,
has.
once the caste certificate has been held to be false by a competent authority, there is no need to initiate a departmental proceeding. It is a conclusive proof of everything because that particular proceeding is held after giving due opportunity and the caste certificate is subject matter of consideration. The parties know about it, the evidences are led, the records are verified, and the authorities come and then they. And the only remedy is a writ petition against that scrutiny.
Lordship, I put a question to myself. I have an employee. He has a right of being charge sheeted if he conducts any misconduct. He has a right to face a departmental inquiry. Now, in place of that employee, some XYZ comes and starts working. I will not allow him to continue in job. He cannot have a right of
It is not
departmental
a
inquiry.
case that XYZ comes.
Yes, it is a case of XYZ comes,
Just a
Your Lordship.
moment. This lady has been working for years together.
Original employee was working for years together, not this lady.
Then
Original
how do
employee
you-
left.
No, that is incorrect statement.
Lordship, you kindly see, I am reading out.
Working 2 or 3 years, that is their case. After that, she was mentally.
And that was verified by police authorities also.
Who was absconded.
You see, police authority, you didn't even register a case against her, criminal case against her of impersonation.
Not only this, when we conducted an
Why?
inquiry to establish.
Who was to be blamed? Who was to be protected?
Lordship, my original employee is to be protected.
Why should you protect a person who allows an
No.
imposter to work?
No, she did not allow. She left the Lordship. Now I say that if some protected means protected under law. If an employee who has entered employment, she has a right of departmental proceeding. Not a person who has Lordships started impersonating an employee. If we did
The finding that she is an imposter
is pursuant to
itself-
an inquiry conducted.
No, that inquiry is not conducted pursuant to any charge sheet, nor it is a
That
departmental
is my
proceeding.
case. I
On the
satisfy your
basis of
lordship,
that
yes.
inquiry report, you could have initiated a departmental proceeding that on the basis of this inquiry, this is the charge sheet against you
That is
as
it.
per the standing order, and now you respond.
Lordship, I will satisfy your lordship that if on the basis of a charge sheet inquiry report, lordship, an employee, a regular employee has a right of departmental inquiry.
What do you mean? They will ask for a departmental inquiry,
No.
or you will issue them a charge sheet.
Charge sheet can be issued to a person who is my employee.
It is as good as saying that can you convict a person for an offence without instituting an FIR?
No.
It is as good as saying
No,
that.
it is. I'll just. Lordship, there is a small
You
distinction.
need to.
Yes, there is a small
It
distinction.
is not a case that she has admitted. It is not a case of admission.
She has admitted that she is wife of some other person and she is not able to identify the person who is there in the
Before whom has she admitted? She has given you in writing?
Lordship, I'm just reading out your lordship.
Has she given you in writing? And
Yes,
what
yes.
was the exhibit? What was the exhibit to that effect?
It has been marked as an annexure by them.
Not an extra. You just talk
No,
about
it
the
was
records.
marked as an
No,
exception.
whosoever has filed it. We are going only by the records before the learned labour court. We will
Lordship,
not
can
go by
you come
any
to page
document.
57?
What is the exhibit number?
Lordship, that I have to correlate with the reports.
Records are called only for this only.
Yes.
We don't want any foreign documents on our record. It was not placed before the learned labour court. We are on 227, right?
Yes. Lordship, can you say page 227?
It makes no difference. We are just, the scope is limited to the extent of perversity.
Lordship, can you come to page, it starts from page 57. Lordship, can you come to page 58? It is exhibit 14.3 or 14 by 3. लास्ट पैराग्राफ मैं काली देशवाली जो मेरे नाम के सामने पुराने और नए फॉर्म बी में वाइफ ऑफ काली देशवाली लिखा है मैं काली देशवाली को नहीं जानती हूँ दिस appellant is saying in the service book of the original employee the husband's name is mentioned as Kali Deshwali and before the inquiry committee this Kali Deshwali had appeared. उसके ऊपर वाला पैराग्राफ मैं अक्रू देशवाली पुत्र रोहित देशवाली और भटनी देशवाली नाम के किसी व्यक्ति को नहीं जानती हूँ और ना ही कभी उनसे मिला हूँ लॉर्डशिप अक्रू देशवाली इज द सन ऑफ द ओरिजिनल एम्प्लॉय
When a complaint is annexure 9 page 62 kindly see that. In what finding one
Anyway, we shall hear it
her
further.
mother
कल सुनते
कल छोड़ के
कल छोड़ के क्यों?
Yeah.
मैटर छोड़ के कौन सा मैटर सुनिए?
ऑलरेडी लॉर्डशिप
नहीं इतना सुन लिया अब तो नहीं इतना देर सुनिए. रिकॉर्ड पढ़िए आप लोग अपना ये एनसीईआरटी.
नहीं रिकॉर्ड के लिए पढ़ने के लिए नहीं है लॉर्डशिप डे आफ्टर टुमारो रख दिया जाए इनका भी कन्वीनियंस है ये लोग भी आई एम नॉट सीकिंग फॉर अ लॉन्ग टाइम लॉर्डशिप हम लोग को भी तो
या फिर तुम्हारे में कोई मैटर रखे हैं ना? ऑलरेडी रखे हैं. कितना एक तो वो मिस्टर राजीव रंजन वाला
दो
छोटा
केस
सा
फिक्स है दो
The learned counsel for the parties. The matter has remained inconclusive. Post this case for further hearing. We have tomorrow to be taken up at 2:15. Sorry.
डे आफ्टर टुमारो
अपना appearance दीजिए. Mrs. N.M. Pal has appeared online. I joined the proceedings online. आपका कौन सा मैटर है? Yes. क्या मैटर है? सुने हैं हम पहले कभी?
I have a degree in my field, but the respondent authorities are not implementing the duty in my field. The civil appeal has already been dismissed. The review application has already been dismissed. Despite that, it is not done.
कल कर दीजिए. Serial number 20. Let us see what happens. Readings are complete. Readings are complete?
Readings are.
We'll hear it.